Good afternoon, everybody, and thanks for giving up your lunch break for our webinar, Claiming and Planning a CID. Just before we start, I'd like to hand over to the General Secretary, Frank Jones, just to say a couple of words to kick us off. So over to you, Frank.
Thanks, Rob, and thanks all for coming along. This is a webinar that has been prepared by Rob and David as part of our activities for Bettering the Trade Union Week. And as Rob said, it's on the subject of claiming and planning for a contract of indefinite duration. I am sorry for those of you who don't know me. I'm Frank Jones. I'm the General Secretary of IFUT. Very privileged to have that position. And the purpose and the timing of this webinar is to coincide with what we have as Better in a Trade Union Week, which is the lead-up week to May Day, which is on Friday of this week, which is the International Workers' Day, a day of profound significance to us in the trade union movement, where we celebrate some of our wins over the years. We regroup and we focus on what we're looking for and what we're planning and working with our members for the next year. And, CIDs is one of those issues that's very much core to the work that we have been doing in IFUT for a number of years here, for a lot of years here. And we've gained the reputation as the go-to trade union for obtaining CIDs, for obtaining permanency for our members. That reputation is among our members, it's among the employers, and probably not to the extent that we need it to be among those who are not yet in membership of IFUT. And that's a role for us and for every member to pursue. So just, our theme is this year that secure employment is not achieved by individuals alone, it's achieved by collective representation. So I'm not going to delay. Everyone has come here to listen to listen to David and Rob in their discussion on the securing the CIDs. So please go ahead, Rob. Go ahead, David.
Frank, thanks very much. So our expert in residence, David Miskell, the one and only. Many of you who joined us will probably know David from your interactions with him. Very thorough and very knowledgeable on the subject matter. So David's going to give us a presentation and talk us through, in general terms, the process of planning and claiming a CID. So David, over to you.
Thank you, Robert, and good afternoon, all. I should preface my presentation today by noting that in all instances, if one is giving consideration to claiming a CID or believes that an entitlement may arise or such an entitlement may be in the offing, well, then at times it's important to seek specific advice on that, and ultimately because each situation is bespoke to the facts and requires a detailed assessment of the circumstances. That includes the requirements that are set out in the Act and our collective agreements, and indeed the unique circumstances of your own case, the nature of your work, what underpins it, and the specified purpose, and in particular the concept of objective justification, which I will come to in due course. So perhaps just that as just as something to bear in mind in the context of the presentation. Frank has introduced us at the outset just in relation to Trade Union Week. But I suppose specifically ourselves in IFUT as an organisation, we represent academic, research and professional staff across the Irish university sector. And ultimately our aim is to advocate for fair working conditions, job security, and I suppose equitable treatment for our members. Our role is to promote. This takes the form of promoting, I suppose, engaging in collective bargaining for fair compensation, job security, and improved working conditions. We advocate on national policy issues which affect higher education funding and resources, which ultimately loops back in to many of the rationales that underpin the specified purpose or fixed term contracts. We provide support services to members through employment rights advice and representation in the context of complete disciplinary matters and grievances and disputes. And we provide assistance and support with contract queries to ensure fair treatment and employment security. And also, and in this instance, of which this is an example, we endeavour through consultation on our representative structures to provide professional development for our members through workshops, seminars, and training sessions, and ultimately to provide a network with peers and professionals across the sector, which is ultimately to all of our benefit.
Thanks for that, David.
Um,
In terms of claiming a CID, David, could you kind of frame what the most important legislative provisions or collective agreements that are enforced that it underpins I suppose the work that you do in IFUT and IFUT does around claiming a CID?
Okay, so I suppose ultimately the legislative underpinning for the notion of fixed term or specified purpose contracts are regulated by the Protection of Employees, which is the fixed term, colloquially known as the Fixed Term Workers Act in 2003, which was ultimately transposed into domestic legislation by way of EC Directive 19970. That is augmented by the CUSH adjudication process, which is a bespoke agreement between higher education institutes and IFUT. It ultimately emanated from an expert report, and it constitutes a fast track procedure for claiming a contract of indefinite duration. And crucially, it is exclusive to persons who are members of IFUT.
How does that work in practice, David? Because I suppose some of the people joining us may not be members in terms of how is it exclusive to IFUT members? Why is that? Or explain that a little bit.
Well, it's exclusive to IFUT members because IFUT were the drivers behind its introduction, and it is IFUT have signed up with it along with the university sector. So to
It's
avail
essentially
of
an agreement between the
the
parties.
collective
Yeah.
agreement exactly between the parties. So therefore, that's why it applies and is a major benefit to IFUT members or to persons who are considering becoming a member, in which case we always encourage them to do so.
Super.
Um, but that is, I suppose that, and that's a key important factor. So I suppose the purpose and linking into that, Robert, is I suppose the purpose of the legislation and the CUSH agreement. We have two very specific objectives, and the first one is to ensure that fixed term workers cannot be treated in a less favourable manner than a comparable permanent employee, and that's set out in Section 6 of the Act, and ultimately to prevent the abuse of excessive, continuous fixed term contracts.
Then I
That,
think that yeah, I think the next thing you're going to address for us, David, is this, and Frank will attest to this as well. Is the question we, I suppose, consistently receive is what is in fact a fixed term contract? And often you hear these myths kind of bandied around the universities about specified purpose contracts aren't included. If I had one contract as a lecturer but another as a teaching fellow, and all of these different myths around it. So I think it would be important if you could kind of give us just a brief overview of what on earth is a fixed term contract.
well, a fixed term contract or a fixed term employee, it's a person having a contract of employment entered into directly with an employer where the end of the contract of employment concerned is determined by an objective condition, such as arriving at a specific date, completing a specific task, or the occurrence of a specific event. And for the purposes of the Act, there is no difference between a fixed term and a specified purpose contract, and that frequently is a myth propagated by employers that the Fixed Term Workers Act applies solely to fixed term contracts, as in contracts with a specified end date. That is not the case. It also applies just as equally to a specified
Specify.
purpose contract, and indeed they are one and the same for the purposes of the Act. There is also, and much of this obviously has been tested through the various cases that IFUT have brought over the years in relation to both the agreement and the Act. and
Okay.
there have
Right.
been certain positions taken by employers in relation to so for the purposes of the CUSH agreement, that all of the service has to be at lecturing service, and that is not the case. That you only require one contract as a lecturer, and that obviously contract be extant at the time of the claim, whereas previously the employer's position always adopted the position that if you needed to have all of the service at lecturing grade, or similarly more generally under the
Mm.
Act, in respect of researchers, or what's termed casual employment or hourly paid employment,
So they are all included
that was
for the
not
purpose of
included.
a claim.
Yes, they are all
Uh,
included for the
uh,
purposes of a
and
claim.
I might quickly go to Frank on this for a second. Would you see those sort of often, Frank? Would you see those propagated and those myths? You're around IFUT for a long time. Is that a familiar sort of scenario
It,
for you?
yeah, it's been the case for longer than I've been with iFoot. And what we have seen, and you've seen on your watch, and more recently, even David, you've seen it too, that the approach that the employers are taking um, differs and evolves, I suppose, over time. They get wiser to some of our arguments, and they present the same fixed term contracts in different ways um, to support differing arguments. But we've kept one step ahead of them. I would think that the actual use in the first instance of fixed term contracts and repeated fixed term contracts has lessened over the years. But it's getting more complicated, as David, as you'll attest to, in the taking the cases. It's not as simple as it was when we first started taking those cases in 2018 and 2019.
Mm. So thanks for that, Frank. So David, I suppose the next kind of question that I think you're going to deal with is, well, what is a contract of indefinite duration? And people often have differing expectations as to what that amounts to. But I think you're going to give us an exquisitely simple sort of a rundown of what in fact a CID actually is, or a COID as they often call them in places like Trinity and others.
So a contract of indefinite duration, it has many of the attributes of a permanent contract. And ultimately, a contract of indefinite duration, or CID, should ultimately mirror the fixed term contract, which brought the person to the qualifying period of 4 years or 2 years under the Cush agreement, but has no termination date. So, in essence, and I suppose in straightforward terms, it is an exact mirror of the contract that the person is on at the material time under the legislation that it transmuted into a contract of indefinite duration, with the removal of the temporal limit, or indeed the the limit that is imposed by the specified purpose. So I suppose that is in essence the what is the contract of indefinite duration. And sometimes, again, there are differing views or different perspectives on what that is. But in straightforward terms, that is what contract of indefinite duration is. And that is, in essence, what is claimed through through the relevant process where we intervene.
So in that sense, then the timing of a claim can be important depending on what contract you're on at the material time you make the claim, etc., etc. They are all moving
Yes.
parts that you probably need to seek advice from yourself or head office or your branch committee on, because they're debatable, really, aren't they? Those kind of things, you know?
Oh, yes.
Yeah.
Ultimately, the timing of any claim is also an important factor.
Mm.
I suppose, because one must make, now the reality of it is that people, not everyone does, and that's why we always encourage people to be a member of a trade union, so one has access to advice, but not just access to advice, timely advice, and to make then appropriate decisions on what, if any, steps can be taken to regularize your situation.
Planning is important, yeah. Do you want to take us through then what the protections of the Act and or the Cush agreement actually is afforded to a member or to employees? Do you want to take us through that?
So the specific protections, there's a number of them set out in the Act, the most significant of which is contained in Section 9 and it's subsection 2. And where a fixed term employee has been employed on two or more successive fixed term contracts, the aggregate duration of such contracts shall not exceed 4 years. Now, in practical terms, that means that an employee employed on a fixed term or specified purpose basis for a period of in excess of 4 years can claim a contract of indefinite duration. And under the CUSH agreement, the aggregate duration of such contracts shall not exceed 2 years. So, in essence, they under the CUSH agreement, that is a more favourable arrangement. It in essence reduces that 4 year requirement to two, which is in essence more, which is manifestly more valuable and secures a fast track route to attaining a CID.
Very, very beneficial indeed, isn't it? Yeah, yeah. And then just in terms of sort of the eligibility, David, is it a complicated process? Again, is there moving parts to this? Could you take us through and give us just a
Well,
brief?
so the eligibility criteria under the Fixed Term Workers Act, the 2003 Act, uh, is it requires mutuality of obligations, which I will go to in more detail further on. And it requires under the Fixed Term Workers Act, you must have two or more successive fixed term contracts. The aggregate duration is 4 years or more, and it applies to any university employee or indeed any employee in any sector, but specifically within our own sector. It's any role, regardless. It
Mm,
applies equally, regardless of what role you have. The CUSH process has similar attributes, but ultimately requires one to be engaged in lecturing duties, which broken down on the
okay,
40-40-20 research lecturing and contribution to scholarly activities, and researchers and tutors are expressly excluded.
okay,
Albeit I should note that as part of our collective bargaining claim currently, we are seeking that researchers and tutors are to be included in it, because it is our experience that since the inception of the agreement, that a number of universities have disaggregated the constituent elements of lecturing duties and afforded them titles such as teaching fellows or teaching specialists, sort
mm,
of a whole amalgam of different titles for the purposes, we say, of putting them beyond the scope of CUSH. And again, these are matters that we are maintain under active review within IFUT and form part of our collective endeavours with a view to ultimately addressing the issues of precarity that are pervasive across our sector.
So then I might come back to Frank for a second. I suppose Frank, again, in your experience, then it would seem to me, is notwithstanding what you might be titled, it's important that that title reflects the duties. So don't be put off necessarily by the title, I guess. Do you have
Yeah.
any?
Yeah, you just, I mean, as David says, I mean, the initial protection is under the fixed term work legislation, which covers you on the contract that brings you over the 4 years. Could be your second, could be your third contract that brings you over the 4 years as a service. Um, and the employers have, as David said, made efforts to try and minimize the opportunity that we have for successful outcomes on taking these cases by defining a lecturer as something else.
Mm,
Now, the definition of a lecturer within CUSH itself is a lecturer is somebody who's contracted to undertake lecturing duties. Um, so that's where they get out of some cases with ourselves. But however, there's still the protections of the fixed term legislation apply. And
yeah,
that's why we need to be talking, those members need to be talking to us and talking to us at an early stage and getting advice for us and
very
not
important.
missing timelines. You don't want to be statutorily barred from taking a case because a member has missed a timeline.
Yes,
So get to us early. And there's no qualifying service with an employer to become a member of a trade union or a member of IFUT at least. Um, we don't have to wait till somebody gets permanency or somebody has a year's service.
good point. Thanks for that, Frank. David, you have mutuality of obligations starred, double starred, in fact. Sounds a little bit complicated, but I think you're going to give us a short kind of overview of what that was, and now is again, because that seems to be a shifting piece of ground.
Indeed. So the case that sets that down is the Minister for Agriculture and Food versus Barry. So, and a direct quotation from that judgment is it describes it as a requirement of mutuality of obligation is a requirement that there must be mutual obligations on the employer to provide work for the employee and on the employee to perform work for the employer. If such mutuality is not present, then there is no contract. Now, that might sound somewhat of an obvious point, but it has been the subject matter of some debate in the context of litigation regarding contracts and workplace relations commission cases. The mutuality of obligations was canvassed specifically in this case, the revenue commissioners um, versus Carson, which was trading as Domino's Pizza. In essence, it was concerned itself with an examination of whether or not the persons that deliver the pizza can be regarded. It was an ultimately had it is their assessment in relation to taxation, but the taxation element required a review of whether or not there were could be classified in essence in an employment relationship.
Mm.
And in that case, the judge was satisfied that the type of mutuality of obligations contended it didn't form part of Irish law, which was in essence the sum totality of the position of Domino's Pizza was the drivers were not, there was no mutual obligation
Yeah.
to attend for work.
And
Uh,
that's important, I guess, in a higher education context, because I think what you're getting at here is that heretofore employers were trying to discount service that was carried out under what they are kind of terming casual contracts, or you might have done a couple of semesters, and they were trying to say, well, actually, there, you know, when claims are lodged in the past, they were trying to make out a case that actually there isn't a mutuality of obligations. We offer you a bit of work now and again. You're not obliged to do it. We're not obliged to give you any, and therefore you're not covered by the act. So,
Rob, can
yeah,
I get in there?
sure, Frank. Yeah, yeah, yeah.
Just because, it might seem that the whole argument of mutuality of obligations is something alien to the sector. I know you're saying that it's not, and clearly it's not. We had one university back several years ago that said that hundreds of its lecturers were just deliverooing, and that wasn't their word, that was my word,
Mm,
deliverooing lectures, and that there was no mutuality of obligations, and that these lecturers, some of them who relied solely on that employer for income, that these lecturers were self-employed, casual, and they were not employees of the university. It was an outrageous position for a university to take. They stood over it. They argued it in many processes, and we weren't able to get a lot of those cases in before Cush because of the argument of whether
mm,
these were employees or not. Now, I don't think that that is as pervasive as it once was, but it's something we've got to watch because all it takes is one rogue ER or HR manager to pursue this. And then, it becomes, unfortunately, it becomes a race to the bottom and very attractive for other universities to pursue it. But it is real. I mean,
yeah.
unimaginable a few years ago that a university would do such a thing
Mm.
to consider hundreds of its employees not to be employees at all.
But thankfully, the Cashran case, David, would appear to have put that back in its place, and the jurisprudence, as a result of that, would appear to be that service, all of that service, is at least in play. Would you
Yes,
agree? Yeah.
yes, and it's in play on the premise that ultimately, if it's agreed to pay someone where they intended at your premises and available to the work, the contract was capable of being an employment contract in our own instance, capable of computation, capable of availing of that service and pointing to it for the purposes of commuting
Mm.
global service for a CID, and it restores the law to where it stood in 1998 with a case again that concerned itself with Henry Denny and Sons and the Minister. Again, which was again determining the employment status of, as it was at the time, demonstrators in a supermarket, which again, that label of casuality was applied to them. The use of those terms, I believe, is problematic, or hourly pay, or casual employment, or other such language. The implication of that is that somehow that
Mm.
the persons providing that work are not performing a valuable aspect of the university's function, which isn't the case just because I label something as hourly paid or in some way casual. Ultimately, it's our contention in any event, which is a reflection of the law, that there's not necessarily a choice of not going to work. One can make a choice not to go to work, but then one is not in a position to pay their bills. So that is a very important decision and a very important development in the law that we have applied positively in relation to our own work, on behalf of our members employed in lecturing roles, research roles, and a variety of other contexts.
And how have we adopted our strategy, David, to move with that? Are we more sort of cases we mightn't have considered to be able to pursue in the past? We're kind of we're able to run those now. So some of the perceived wisdoms around those might have shifted, and maybe people joining us today might have been advised in the past, rightfully, in the context is, that they didn't have mutuality of obligations and now have. So people should, I guess, kind of contact us if they have any questions in regards to whether or not kind of casual service that they might have had and they might have thought they didn't have an entitlement to a CID. It'd be important for them to maybe reassess that in light of the kind of shifting ground, would it?
Yes, that obviously we, in any set of circumstances, apart from providing advice to our individual members, that advice is ultimately informed and underpinned by developments in the law, which are ever evolving and one that we must keep abreast of. So, of course, if there are scenarios where one would think that one might have perceived it to be the case, or indeed have been previously advised the case that that service was not reckonable for the purposes of calculating service for CID attainment, one could, of course, revisit that and seek advice from us on an individual basis in
Great.
relation to addressing or progressing a CID claim.
Thanks for that, David. I think that's a nice segue into our kind of next topic, which is continuity of service, because again, as I mentioned and you mentioned from the outset, CIDs and CID claims are extremely fact specific. So I mean, there's some kind of guidance around, well, what service is included, what service isn't included. We have lots of academics on term time contracts. They're laid off for the summer. I mean, lots of people are of the opinion that because they're laid off for the summer, that their contract is broken every summer, and therefore they might never be entitled to claim a CID. But you might be in a position to kind of clarify some of that for people joining us today.
Okay, so I suppose, yes, continuity of service is a key element because the requirement under the legislation and the collective agreement by way of CUSH is that it is continuous service. So continuity of service is not broken by dismissal followed by a period of re-employment, and that principle has been set down in the case of Department of Foreign Affairs versus a group of workers. That's a 2007 case. Um, the aggregate duration of the unpaid periods between contracts, again, that go with the normal academic cycle, does not break continuity of service. And I suppose, again, it's important again to seek advice specifically. Generally speaking, the law would say that any period that is under 26 weeks, it will not break continuity of service. And I would say that with the caveat that I would require to look at someone's contracts and any specific sets of circumstances surrounding that break. But very frequently in the higher education sector, be it researchers or lecturers or persons in other grades, you will have breaks in service in the sense that, that will go with the normal academic cycle. So again, those are not to be regarded as breaks in service for the purposes of continuity, because at all material times one maintains their employment within the university. But again, just to be conscious of that as well. But again, each case is fact specific, and we will provide an assessment and advice
Mm.
bespoke to your own circumstances for
But I
anyone
suppose
that comes to us.
the general message though is don't take for granted maybe what your HR manager or line managers might be saying to you around that, because I know when people come to me, there will be like, I'm only checking it out because I don't think I'm entitled to it because I had the break. So it is important, again, to have that checked out and to look at that before anybody makes assumptions of what they are not entitled to. How then, David, if how does the provisions, or what do the acts say about kind of, if you have if you meet the criteria, you have the sort of the 4 year service, the two contracts, or the 2 years and the two contracts for Cush. What do the provisions of the Act and or Cush do then? What do they do to that? Or can they override a contract, or how does that work?
So the strength of that provision is ultimately is seen as Section 9, it's subsection 3 of that Act. Provides that where a term in the fixed term contract purports to contravene either subsection 1 or 2, the term shall have no effect, and the contract concerned shall be deemed to be a contract of indefinite duration, or in the legislative parlance, will be one that transmutes into one of indefinite duration. And this can only be avoided where the employer can meet the onerous test of establishing objective grounds justifying the renewal or issuing of the contract ab initio on the basis that they did.
Okay, that's interesting. And um, so for instance, you'd often find provisions in contracts that said this is not a permanent contract, and we never intend to give you a permanent contract. So it would actually, I don't want to misquote you, but it would essentially void those provisions, the end date or the end provision, if you meet the criteria, and I know you're going to move on to objective justification, but if you can essentially, if it's not objectively justified, um, essentially, is that the case? Yeah.
Yes, if it can't be demonstrated that there is an objectively justifiable basis for issuing the contract on the basis that it was, i.e., a fixed term or a specified purpose, well then that term shall be voided and the contract will be deemed to be one of indefinite duration by operation of law. So that is
Frank, before we go to objective justification, is that something you'd have ever come across
Yeah.
yourself? People kind of again expressing the opinion that I'm not entitled to it because my contract says I'm not entitled to accrue a permanent
Yeah,
contract. Is that confusing for people, do you think?
it is confusing, and it's confusing for people because again, look, there's no power balance when these contracts are being signed. I mean, when they're being signed in the first instance, it may be a few weeks before a person starts employment. They're not going to be a member of a trade union, very likely, because they're not an employee. They signed the contract, and it may have a very small clause in it saying our objective justification for issuing a fixed term contract as opposed to a CID is because we're not sure if it's going to be enough students for this subject in 2 years' time.
Okay.
If that subject was, for example, history,
It's
it's
not really
very
going out of
questionable.
fashion. Yeah.
Yeah, but we've won as we know, and many members do know, we've won a lot of cases on the basis that the objective justifications were just makey uppy.
They weren't
They,
bona
they, they
fide.
were. It was just to get a fixed term contract signed. So they have to be thought out. That you have
Mm.
to be the member. If the member is persuaded that the objective ground is justification is legitimate, well, then the member is unlikely to come to us in the first place.
Mm. Mm.
But I would say to members and non-members, look at the objective justification. Have a look. Is it considered? Is it legitimate? Um,
Uh,
but we've won a lot of
And
cases.
David, could you tease us through then what the Act says about that? Because that is, I think people generally feel, well, I have the two contracts, I have the 4 year service, or I have the two contracts and 2 year service for coach, and that's kind of it. But there is this piece to overcome. Do you want to explain that a little bit for us, and for people joining us? I don't think we need to go into too much detail, but just a little bit, if that's okay.
So I always provide advice at the outset of any claim, meeting the criteria of the 4 years continuous service and two or more successive fixed term contracts, or two in the case of Cush, is required, but in and of itself is not determinative of CID entitlement, and one must canvass and assess the objective justification that is provided in the contract and surrounding factual metrics in relation to the employment, specifically Section 7 of the Act. It provides for objective justification of less favourable treatment on certain grounds for the purposes of achieving a legitimate objective of the employer, and such treatment is appropriate and necessary for that purpose. Ultimately, objective justification, examples of objective justification can vary very widely, and their genuineness or otherwise also, unfortunately, can vary widely as to whether or not they are appropriate and necessary. And frequently, in a lot of cases we find that they do not and are not appropriate or necessary for that purpose. And unfortunately, it remains an ongoing challenge within the sector to that the prevalence of this form of contract for researchers, academics, and other persons. Ultimately, objective justification, it can't be used as a safeguard against the risk of having too many employees, or in general terms, to inoculate employers um, in respect of future fall off in demand, for example, for courses or of funding. It cannot be used to fulfill an ongoing and permanent need or an aspect of the university's academic offering. And the objective grounds relied upon at a hearing must be the operative grounds relied on at the renewal of the contract or extant at the conclusion of the contract.
Mm.
And ultimately, there must be something clear and discernible. So, examples of something that might be regarded as clear and discernible and capable of justification would be matters such as covering sabbatical, covering maternity leave for for a specific person, and that can be demonstrated that is the case. Whereas something vaguer, such as student numbers, broad phraseology in relation to the development of modules or programs in general, they are less capable of being justified into meeting that criteria of objective justification.
It appears to me, and I think the next slide that you're going to present will deal with it, but it does appear to be a bit interpretive. So it seems to be a bit of a battleground, if I may say so. So could you reach to some examples for us in terms of cases that have been taken, or precedents that exist around kind of objective justification and what it means for members?
So objective justification, as you've correctly alluded to, Robert, is what fact specific, and very frequently argumentation pertaining to contracts of indefinite duration rest on the issue of objective justification, because the other criteria of 4 years service and two or more fixed term contracts are generally arise as a matter of fact, that those are generally not disputed, leaving aside arguments around whether or not service is reckonable, or those are things one will either have or will not have. um, there is a case that underpins a lot of our engagement, and then looking at examples of objective condition. Objective condition is regarded to mean a condition which is identified by reference to the object, that is to say, the condition, without reference to the view or perception or intervention of
Hmm.
either party to the contract. For example, in the case of a specified purpose contract, the purpose ceases once that program ceases. Or alternatively, a fixed term contract to cover mat leave, that contract comes to an end um, when the person returns. So those things are objectively regarded as something that's clear and discernible, whereas other more nebulous phraseology, such as the development of modules, student numbers, or a whole host of other labels that are applied to various employment scenarios, are less clear and
Yeah.
discernible. But as I said, each case requires a fact-specific assessment. As we've alluded to, the law is ever evolving. We Some decisions are favorable, not all of them are. We generally operate on the basis we progress cases that we consider to be statable, and ultimately, while one can't guarantee the success or otherwise of any claim at the outset of the matter, as it's an unknown variable, we will generally provide robust advice in relation to whether or not we believe there is, the relative strength of the case. And just to juxtapose an example of two cases where I referred to something specific. In one case with UCD, the employer argued the claimant had been employed on fixed term contracts to cover maternity leave for two named employees, and the Labour Court held that there was no objective grounds and found that the claimant undertook work that had no relationship to that which had been carried out by the two staff members whom she was allegedly replacing. And that can be juxtaposed. Again, similar scenario, the case of Squellara versus McCarthy. The claimant ultimately failed in the claim for a CID as she was employed to cover a permanent music teacher, and that is in fact what she was engaged in. Now, we have had some recent decisions that are a source of concern to us in relation to the issue of what label is applied
Mhm.
versus what duties a person is engaged in, which requires some review on our part in relation to its applicability, going forward. But again, as I said, each case is fact specific, and ultimately one must respond to decisions as they
And
emerge.
and you said something there, David, that struck me, and I think you're going to deal with this as well in a bit in terms of another example. But you said that kind of an oversupply of labour or having too many employees or course numbers or these spurious kind of reasons that are often generally given isn't really a protection. I think you have an example of that for us there in Chagos versus McNamara. I can confirm it wasn't me who took the case, a relation of mine.
Indeed. So this Chagas v McNamara related to a researcher on funded contracts and the use of successive fixed term contracts indefinitely in scenarios to protect an employer against the possibility of an insufficient supply of work at some point in the future, seriously undermine the effectiveness of the directive and the Act. And if due to economic circumstances or fall off in demand, there is no longer sufficient work in order to maintain a worker in employment, well, then the employer's remedy lies in making surplus staff redundant. And this is a notable case in that it is authority for the proposition that if the purposes of fixed term or specified contracts are to fulfill a specific need for a specific time of an employer. They are not to be used in general terms to inoculate employers in relation to loss of funding in the future or future fall off in demand, more notably, well, across all of the sector, but perhaps most notably again in regard to researchers, the proposition of funding, or what we consider to be a contrived distinction between various such as core funding that comes, for example, directly from a department, or then funding that comes from an external source or entity to sustain a particular stream of research. And very frequently, the argument will be made that we cannot give a permanent contract or a contract of indefinite duration because we don't have the funding on a permanent basis. And what we say to that is that that is not in and of itself justification, simpliciter, or wholesale for issuing a multitude of specified purpose or fixed term contracts. And that ultimately, should a set of circumstances arise in the future
Mm.
where there is no funding to sustain an employment, there are a host of options available to employers within the architecture of employment law, such as short time working, layoff, or ultimately redundancy, and that those are the vehicles that should be availed of and not specified purpose or fixed term contracts because of
I,
the potential for that happening.
I think that's a very welcome um, clarity, David. And Frank, to yourself, I'm sure you'd have seen reasons like this time after time relied upon with regard to our researcher colleagues. You'd have this, and you'd have maybe the more nebulous characterization of postdoc researchers as training roles so as to try and circumvent the provisions of the legislation. Did you want to
Yeah,
talk on that for a second?
I will, Rob, but you're at risk here now of opening up another seven webinars immediately because they're huge. They're huge issues, and in the classification of workers as students and the paying of wages as stipends. I think we'll have to leave that till another day. But on the very specific issue, we have this thing that prevails still that the employers use regularly and constantly as an excuse for not filling positions where there's a need to fill the positions. And that's the employment control framework. And I bore people when I talk about this
Hmm.
because I have the I call it by its legitimate title. It's the Employment Control Framework, 2010 to 2014. It had a start date, like a fixed term contract, and a finish date. And yet the employers still say that they're bound by this document, this austerity document, which prevents them from which sets a cap, an arbitrary cap on the amount of permanent employees that they can have. We so many arguments we have presented to the department and to other at other arena where we have successfully got the other side to agree that the employment control framework should be lifted, but it's not.
Hmm.
It's putting
Huge
pressure on
concern
the
still.
HR departments not to fill permanent vacancies with permanent employees, and it's wrong. But it's something that we push every pre-budget submission. We push every opportunity that we meet with those in authority, and we'll continue to do so. But it's just another challenge. It doesn't stand up as an objective justification. Um, just to
Thanks for
say,
that. Yeah, and I think you're right. I think it might lead to another webinar actually in terms of researchers' rights because I think there was many mistruths spoken about what the researchers are in fact entitled to. But I think just simpliciter in terms of the point that I was making to you, the this reliance on researchers, a training role, postdoc researchers in particular. Was something that has been used by a number of institutions in the past, but actually the Act prescribes what a trainee role is and what is actually specifically excluded from the Act, and it's nurses, guardies, and doctors in training, and that does not mention. I think apprentices. It does mention apprentices, but does not mention any other roles. So it'd be interesting, maybe at some future stage to go through that in a bit more detail, David. But David, moving, I think again a good segue into kind of circumvention because we do. Quite apart from research roles, we do see attempts to circumvent the Act. So, do you want to take us through the provisions in relation to that and any kind of interesting cases that might have occurred in that stream of things?
Yeah, okay. And just again, I suppose just to note in relation to funding and linked to CID claims, it's very important to seek specific advice because again, and the recent decisions, have created a layer of complexity around that. So again, it's important to seek specific advice. The Act also prohibits penalisation, Robert, as you've touched on. Specifically, Section 13 of that Act says an employer shall not penalise an employee by dismissing them from their employment if it's wholly or partly or connected for the purpose of avoidance of a fixed term contract being deemed to be one of indefinite duration under Section 9, subsection 3 of the Act. And unfortunately, that is a situation we encounter also where universities, for researchers and lecturers, actively seek to avoid someone coming in scope for a contract of indefinite duration as part of an wider organizational policy. The case that we've dealt with, where this has been demonstrated to be the case, was that of Kennedy versus Trinity College Dublin, and ultimately a quote from that. It was the central issue is whether the risk of him acquiring a CID was an operative factor in the decision not to appoint the person in question to a role, and it was not possible to reconcile in that instance the tone and content of an email, which made such inferences, and the subsequent decision not to appoint the complainant. And on the balance of probabilities in that instance, the adjudicator was satisfied the prospect of the complainant acquiring a CID was an operative cause in the decision-making process. and found in his favour and awarded him just over 30,000 euro. So again, as you know, dismissal itself for failure to renew can constitute penalisation. Penalisation can take many forms, such as promotion, allocation of duties, and so forth. And again, we always urge to seek advice. But I suppose in the context of this presentation, it's important to note for persons perhaps giving consideration to making a claim that there are specific protections available for persons who are the subject matter of adverse treatment or penalisation as a result of having sought to vindicate your rights under the 2003 Act, because very frequently we receive contact from members who are worried about pursuing it or fear of some form of repercussions, or that that there'll be some type of adverse treatment, or that it won't go down very well in ordinary man's language, that someone is making such a claim. And we always in this instance try to provide that reassurance such an eventuality arise and it is capable of being demonstrated. Well, then there are avenues which IFUT can pursue to protect our members in relation to such situations.
Thanks for that, David. And maybe then just maybe more practically for a second, um, sort of what can people what are the top tips for a person, a member or non-member, kind of planning your application? What are the important steps that need to be taken?
Okay, so I would always plan one's application carefully. That means always maintain some form of vigilance over that what contracts you were issued. Try to keep copies of them. Um, the most important one is what I always say to people is please do not wait until your contract is due to expire next month, and then there's a panic about the matter. To maintain ongoing vigilance in relation to what you are issued with, why you are issued with it, keep copies of it, and to ultimately assess it in a timely fashion and not wait until the contract is due to expire. Keep a note of duties undertaken outside the contract. We always also encourage people to consult your local branch committee in the institution that you're employed in, and at all times necessary to consult with IFUT head office. If you are making a claim, it is preferable to do it on the standard IFUT claim form for such an eventuality, which covers all your service, but it also has phraseology that is of assistance under the Act, which makes it clear that a claim is being pursued and what the claim is, and the legislative provisions that underpin it. And it's very important to be clear if there's a subsequent case that a claim is properly made and clearly made based on all the available information.
Super. And David, having followed that advice, say you're refused by your institution, as often happens as the first response to these things, could you tell us what IFUT will do in the process for members, either at the Cush adjudication process or at the WRC, the Workplace Relations Commission, if we have to refer it there? I mean, can you tell us how that works? Just in a couple of words, not.
Okay. So ultimately, which again is frequently the case, that a claim is declined at first instance locally, well, in that circumstance, it will refer to the CUSH adjudication process that will mean that we will make a submission on your behalf in consultation with you. The case may be solely decided on written submission at the chairman's discretion. An oral hearing may take place, but the agreement says that that is in exceptional circumstances and a decision is issued in a relatively short period of time. Now, again, we have encountered some delays recently, but ultimately, generally speaking, it is in a relatively short period of time. If something is referred to the Workplace Relations Commission, that is a more lengthy process. It can take up to 6 months from point of referral, and longer in some instances to have a hearing date. Again, again the hearing date. That is a public forum. It requires someone to give evidence as to their contracts and provide the facility for IFUT representatives to cross-examine employers in such matters. So again, a slightly different forum conducted in frequently a different format, but ultimately has the same aim. And again, we provide specific advice in relation to what avenue we pursue depending on your circumstances.
And then, David, often CID claims as you say, kind of cross over into other employment rights and um, areas such as redundancy and unfair dismissals. And what other strategies, defensive strategies, would IFUT sort of pursue from time to time when people find themselves? It could be that you may not be entitled to a CID, but you may be entitled to redundancy and so on and so forth. Can you take us just a brief word on that, perhaps?
Okay, so redundancy then is a strategy that can be deployed as in if it's not just the contract terminate, if the contract terminates and if you have the service, you may be entitled to a redundancy package. That's 5 weeks or 4 weeks pay inclusive of statutory, which is 2 weeks pay per year of service. That's applicable to the public sector. And that can act as a deterrent. There are also sections of the Croke Park Agreement, which is the overarching public service pay agreement from 10 to 14, as amended by its various iterations over the years, applies to all public servants, and the employment protections measures are not absolute. In order to avail of them, a public servant must cooperate with redeployment and relocation measures set out in the agreement, or otherwise they may be made redundant where the work they perform is no longer required. But the existence of that public services pay agreement also can, in appropriate circumstances, provide an avenue which to test the providence of the employer's position around the contract actually expiring when one gets into issues such as redeploying or relocation measures or taking sufficiently robust steps to avoid redundancy.
Thanks. And then is there any kind of? I think you have you can reach for another Trinity case for us there in terms of a practical demonstration of something of that nature happening.
Yes, another strategy available under employment legislation is that of unfair dismissal, which is again a case with Trinity College. And I suppose in that instance, the court accepted on balance the requirements of the university for the work complainant was carrying out in that instance had ceased due to the lack of funding for that role. However, the court also noted that he was no longer on a specified purpose contract and was now on one of indefinite duration, and it was clear to the court in that instance that sufficient efforts were not made to seek alternative roles for him, and the court cannot in that instance and did not accept that his dismissal was by virtue of fair selection for redundancy, or that the burden had been discharged by the respondent, and found that the complainant was unfairly dismissed.
So
In that instance, the
that's a
unfair
hugely
dismissal is
important
something that
point,
can
David, isn't
apply.
it? That's a hugely important point in terms of the obligation of the employer, because sometimes people do feel disposable at times, and there's generally an obligation to try and work with that person before they make you redundant.
Yes, regrettably,
Yeah.
we encounter scenarios where the contrary is the case, that employers are seeking to arrange, not in all instances, but very frequently, are seeking to avoid a CID as opposed to finding alternatives to redundancy or maintaining someone's employment because there is that overall policy initiative underpinning um, a lot of contracts within the university sector to maintain people on fixed term and specified purpose contracts, and that's been demonstrated by our own research into this area. So again, yes, it is an
Yeah.
important.
Yeah.
There are particular sections of the Act that require an examination cross-referenced with the contract, as a lot of the fixed term or specified purpose contracts
Okay.
will on their face exclude the Unfair Dismissals Act, but
Yeah.
advice can be provided on that bespoke to your
Uh,
situation.
just then finally, I make a comment on it myself in terms of sometimes people are sort of laid off or finished up from their contracts. Their contracts end, and they don't even know they're entitled to redundancy, and come to us afterwards hadn't even known they were entitled to, in some cases, 30,000 to 40,000 euros in redundancy monies, and the employers simply are not making them aware of their entitlement. So it is very important you're on top of your entitlement. So Frank, the last minute goes to you. Maybe just to wrap up, but I'd like to thank everybody for giving up their lunchtime on a sunny day on this trade union week. It's been an honor to chair this session. So last word to yourself as General Secretary of IFUT, and thank you to David for a very, very insightful presentation indeed.
Yeah, yeah, and thank you again for everyone who's attended and stayed with us throughout your lunch break. I hope everyone found it informative, and I hope if you are interested in follow-up sessions, contact us through the branch or contact us in head office directly, or other subjects like we touched off some of the researchers and the classification issues that we as we touched off. We could go into more detail on that if you want future webinars are around that area around that subject matter. I want to thank Robert and David especially for the work you did in preparing this and the new format that we've taken, which used the chair and the interviewer, Rob. I hope it worked. I hope people like it. And the last thing I have to say is I really hope that it being better in a trade union week, that all of those who've attended and who were interested in this introduce the union to a friend or colleague. That seems to be the greatest reason as to why people don't join the union, is because they weren't invited to do so. So I would just ask you to ask a friend or colleague to join IFUT. It's www.ifut.ie. It's not that difficult. And all I have left to say is happy May Day. Enjoy it and enjoy next Monday, a bank holiday for international workers.
Thanks,
Thank you.
Frank. And for any non-members who are on the call, you can just scan the QR code that I've
Oh, yeah.
helpfully put on screen for you. Yeah, thank you, Frank. Thank you, David. And as I said already, thanks to everybody for joining us. And we're done on time. Thank you very much. Bye bye.
Good afternoon, all. Thank you for joining us.